Hello and welcome to our Retirement and Wealth Strategies webinar series. Today we'll be focusing on estate planning with our presentation, the top 10 myths and mistakes in estate planning. I'll be your host and moderator for the day. I'm Nicholas Scarcella, Vice President of Retirement and Wealth Strategies. Let's start with a brief introduction of RWS. I'll introduce our presenter, Aaron with Taft Law, and then we'll start on myth number 1. First, RWS, we are a fiercely independent wealth management firm with over 35 years of experience. Established in 1985, we've been serving clients nationwide with our Midwest values. We have over 30 advisors, 17 offices, and collectively we serve about 7,000 households across the country. Our core values, these are our commitments to you as our client. Education, trust, relationship, compassion, and competency. Education is what we're doing here today, providing content, education, information to our community and to our clients. Trust, we earn it, never abuse it, and always have your best interest first. Relationship, it turns into a friendship, and we work with multiple generations. Our clients' children's and grandchildren's generally turn into clients, and we pride ourselves on that. Compassion, this is our patience and understanding for your evolving needs and circumstances. And finally, competency. It's our duty to be experienced, credentialed, and knowledgeable on the financial markets and financial planning. Here's our housekeeping. If you're eating dinner, you're yelling at your dog, you're okay. Your camera's off, your microphone's muted. It is a webinar format. We do have a question and answer feature. We'll have that at the end. Unfortunately, because of compliance, we have to do it via text. So I have on the next slide, the phone number that you can text with any questions throughout the presentation. I'll receive those and we'll answer those at the end. The webinar is being recorded. If you want to watch it a second time or a third time, or simply want to share it to a friend or family member you think would benefit from it, we'd love for you to do so. And it's on our YouTube channel or email us if you want a copy. At the end, we'll have a brief survey. This is how we can continue to improve. And there's also a question on future topics you'd like to hear from. The presentation will be roughly 40 minutes, and we'll follow up with the questions and answers at the end. Here's the number I promised. If you have questions, write this down. Send us a text message, hello, 833-797-4636. That'll go right to us, and we'll receive your question. 833-RWS-INFO. So with that, I'd like to introduce our estate planning expert, Aaron Sherbin of Taft Law. He'll provide a little introduction to himself and Taft Law as a firm. Aaron, welcome.
Thank you, Nicholas. It's my pleasure to be a presenter, and I thank you for the opportunity. My name is Aaron Sherbin. I'm a partner at Taft Law. I'm head of our private client group in the Detroit office. Like RWS, Taft is a Midwest firm. We have offices in Michigan, Illinois, Indiana, Ohio, Minnesota, and Wisconsin. We are a full service law firm. We have over 850 attorneys in the Midwest. My area of expertise is estate planning, wealth transfer. I'm a tax attorney and work with all sorts of different clients, whether they be professionals, business owners, entrepreneurs, and work with the very basic estate planning all the way to the more complicated, sophisticated estate planning and anything and everything in between.
Thank you, Aaron. And with that, we'll start with myth number 1, which is estate planning is only for the wealthy.
Yeah, so I'm often told, by prospective clients that they've been holding off on estate planning. They haven't done anything because they're of modest means and don't feel like they have the wealth to engage in estate planning. And nothing could be further from the truth. Estate planning is not only planning to minimize or avoid estate tax, but it's also intended to address things like naming someone to be a guardian for your minor child, or to establish a trust for the benefit of your children should you pass away, or naming people to make decisions for you when you're incapacitated and can't do so, like medical or financial. So if I had to summarize, when we're doing estate planning, we're trying to accomplish the following goals and objectives. Number one, we're trying to make sure that you have a written plan in place that describes how you want your assets distributed to whom, under what circumstances, and at what times. Number two, we're trying to avoid probate. Number three, we want to make sure if you have minor children, you've got someone who can step in and take care of them if you pass away. Number four, we want to have people in place should you become incapacitated. So estate planning is not only addressing death, but we're also addressing the situation when you're incapacitated and can't manage your affairs or make decisions for yourself. And fifth and finally, we do want to try to plan for avoiding or minimizing estate or death taxes. But as you can see, that's only one of several objectives that we want to try to accomplish. So we're not only looking at people who are wealthy, we're looking at any people, any families who have children or who have modest wealth.
And along those lines, Aaron, even if it's a single individual, not married, no kids, they're in their 30s, an estate plan would still be needed, or what would that look like?
Yeah, absolutely. Because in that situation, if that person were to become incapacitated, for instance, as a single person, who does that person want to be making medical decisions for them if they're unable to do so, or serve as their power of attorney for financial matters if they're incapacitated? And also, as a single individual, it may not be readily apparent who that person wants to leave their assets to. And if you don't have anything in writing, your wealth, your assets will be passed on and transferred by the state of Michigan pursuant to what's called the laws of intestacy. So it's really important for our clients to guide and instruct us and anyone else as to who they want to act on their behalf and where they want their assets to go.
Great point. Thank you. And that takes us to myth 2. Joint ownership is suitable as a suitable substitute for an estate plan. And can you explain what joint ownership is? Are we talking about both being on the deed to the house, or a joint checking account, joint investment account? Is that what we're referring to?
That's correct, Nicholas. We're talking about ownership. It could be real estate. It could be an investment account. It could be an interest in a business that's owned by 2 or more people, with the designation that if one of them dies, the other owner automatically takes ownership of the asset. Now, it's really important, and I try to drive this concept home with clients, that there are 3 ways, okay? There's 3 ways you can pass assets on to somebody. Number 1 is joint ownership, right? You and someone else own an asset together, like a bank account, and if you pass away, it's going to go to the joint owner. Doesn't matter if you have a will or trust or what that will and trust says, joint ownership will prevail. The second way is naming a beneficiary. And where you typically find a beneficiary named is retirement assets, an IRA, 401k, SEP. Those assets, you're asked to name a beneficiary, because on death, that retirement account will go to the named beneficiary. The other is life insurance. You designate the beneficiary who will receive the death benefit on death of that insurance policy. And again, that will drive who receives the asset. The third way is by having a will and a trust. If it's not jointly owned, and if it is not handled by a beneficiary designation, then it will pass by way of your will and trust. So we have to make sure that when we are doing the planning, we're handling it and addressing one of those three ways of passing on assets and coordinating all of that to make sure that assets are going to the intended recipients at the appropriate time.
Okay. Great, thank you. That leads us to myth 3. I am married, so I don't need a general durable power of attorney or health care power of attorney, as my spouse can make all decisions for me if I'm incapacitated.
Yeah, so I mean, it would appear that the obvious choice for a durable power of attorney or healthcare power of attorney would be the spouse. And what we're talking about here is when our client is incapacitated, deemed so either by a judge in a probate court or deemed incapacitated by their physician, such that they are unable to manage their affairs or make decisions for themselves. Again, you would think that the appropriate person or the obvious choice would be the spouse. But if you don't have it in writing, it leaves open the possibility for other family members, interested parties, to come in and challenge the authority of the spouse. And so we don't want to leave it to that uncertainty. We don't want to leave it to where we're having some sort of action filed in a probate court to determine who's the appropriate person to serve in that capacity. We don't want to leave it to chance. So we want to have that in writing where we're clearly designating our spouse, if that's our first choice, as the power of attorney for financial and medical. And I would recommend that in addition, you name a successor and maybe two successors to the spouse in case for some reason the spouse can't act. You've got backups who can step in that role.
And successors would be after the primary, correct?
Correct.
Okay.
And they can
So-
be family members, they can be friends, they can be, advisors. It's who's really, who the client feels is most appropriate, responsible to handle those responsibilities.
And what happens if you don't have family? What do you see in those situations where there are not designated family members or even a friend that they trust?
So you've got two different roles here. You've got the durable power of attorney, and that's for financial, versus the power of attorney for healthcare. So, typically when I'm counseling clients on a durable power of attorney for financial, we're typically looking for someone who's got some financial background, who's got some comfort, some familiarity with financial matters, who the person can trust. On the healthcare side, we're looking for someone maybe who's got some compassion, who knows the person on an intimate level, someone who can share the religious, moral, health, feelings about medical decisions. So it's not uncommon to have different people serving in those roles. If there's not, a spouse or a child, for instance, who can be
Yep.
that person.
Okay, thank you, Aaron. Myth 4, putting everything in a trust allows me to avoid my creditors.
Yeah, good question and a common myth. Oftentimes people are under the impression that a trust designed for accomplishing estate planning goals and avoiding probate avoid creditors. Those types of trusts, what I'm talking about is a revocable trust because it can be amended or changed at any time, don't help you or hinder you as vis-a-vis creditors. Okay, so they certainly don't provide you any creditor protection, but they don't put you in any worse position than had you just held the assets in your individual name as opposed to putting them in trust. The main purpose for the trust, or purposes for the trust, is number one, to provide that written plan for how you want your assets distributed, to whom, under what circumstances, at what time, giving the trustee guidance. The second is to create or provide a vehicle for avoiding probate. but the trust is not going to protect your assets from creditors. There are other ways we would have to accomplish that goal. And that's really a topic for another webinar, because some of those methods and techniques can get a bit complicated and detailed.
Before we go to myth 5, a revocable trust can be revised and changed. But what about an irrevocable? Can you just define that and how that functions?
Yeah. So typically we start in any basic estate plan where we're doing the basic fundamental estate plan, the building block, if you will, foundation. We use a revocable trust. And as you pointed out, Nicholas, that trust can be amended, it can be terminated, it can be revoked, changed at any time for any reason or no reason.
Yep.
There is another type of trust, which is irrevocable. Those trusts cannot be changed, cannot be revoked, and we typically see those trusts used after we've built the basic estate plan where we're looking to move assets out of someone's estate to avoid estate tax. We're talking about larger estates where there's the potential for the family to have to incur estate tax. And so we want to move assets out of their estate. We typically utilize an irrevocable trust to do that. And again, those trusts cannot be revoked or amended. They're permanent once created.
I believe we're touching on this later on, but that can tie into estate tax exemption limits and potentially some of the limits that may sunset in a few years here.
Yes.
From a strategy.
Yep, absolutely. A very popular, well, used, very fundamental type of estate planning vehicle to minimize or avoid estate tax.
Great. Thank you. Myth 5, a last will and testament allows me to avoid probate.
Right. So that's a will, and last will and testament is a document that governs actually assets that are part of your probate estate. The way to avoid probate is through the use of a trust. So you create your revocable trust, and then you work with your advisor like Nicholas or myself to transfer your assets to the trust, whether it be real estate, it be your investment account with Nicholas, whether it's the beneficiary of a life insurance product or a retirement asset. There are ways to avoid probate through titling and the use of a trust, but a last will and testament is really designed to cover assets that fail to get into the trust and are part of a probate estate.
Thank you. And just as a reminder for everyone here, I'm going back a few slides. If you have questions throughout, please text this number. Due to compliance, we are not allowed to use a Q&A function. So 833-797-4636 if you have any questions on these slides. All right, let's pick up where we left off. Myth number 6. We sort of touched this on the opening, Aaron, but I am too young to worry about an estate plan.
Yeah, so once you become 18 years of age, you are deemed an adult and legally entitled to manage your own affairs and make your own decisions. And in fact, on Monday, I met with a 19-year-old gentleman to discuss his estate plan. And look, again, if you go back to the goals and objectives of estate planning, again, having a plan in place to describe how you want your assets distributed, avoiding probate, having people, appointed to make decisions for you, avoiding estate tax, those goals and objectives apply to anyone from 18 who's now a legal adult to someone up in their retirement years, and anyone in between. There's no too young age and no too old age to have an estate plan. Now, with that being said, I'm not here and Nicholas isn't here to overcomplicate and over sophisticate an estate plan. There are some basic things that can be done at a reasonable cost to accomplish the goals and objectives. But yeah, you're never too young, as long as you're over 18, to have an estate plan.
Something that just came to mind, do you see a very common situation is you graduate high school, you're around 18 years old, you now go off to college, in-state, out-of-state. Is it best practice to have something in place, maybe not a robust plan, but medical directive, or what does that look like, Aaron? Any best practices along those lines?
Yeah, it's interesting. I am seeing a lot of young adults who are on their way to college, and what prompts them, so sometimes they have very proactive parents who are thinking about those things and getting them to come in and do it. But also these young kids, when they go off to orientation, this issue is raised at the orientation at college. And they're reminded during the orientation process, look, you're leaving home, you're going away, you're an adult. If something should happen while you're on campus away from home, you need to have someone in place to make decisions for you. You need to tell us who we need to reach out to and contact should something happen. And so, some colleges and universities are doing a good job of promoting and encouraging estate planning, along with some diligent and conscientious parents.
Wonderful. Myth 7, there is no need to review and update an estate plan periodically. Is it truly a one and done, Aaron, or how does this work?
Absolutely not. I mean, Nicholas, you and I are meeting regularly with our clients, particularly you are on the investment side, but I am as well, to review and update estate plans. Now, look, families will have events that will prompt a revisit of their estate plan, right?
Yep.
Child gets married. Child gets divorced from a marriage. A child has a child. There's grandchildren who are now introduced into the family. There's an uptick in wealth. There's retirement. Those sorts of life events obviously prompt a revisit of the estate plan. There's also law changes, right? We see administrations come and go. We see Democrats, Republicans take control of the House, Congress, propose estate plan changes, and so that prompts a revisit. But even in the absence of life-changing events or changes in the law, I always recommend that clients pick up their estate plan binder, look at the flow chart and summary that I prepare, and think about whether there needs to be updates. And then I like to meet with clients at least annually, along with the investment advisors, just to get caught up. What's going on, what's happening in your life? Is there anything we need to change? It never hurts to do that on an annual basis.
Same structure here at RWS with life-changing events being a strong reason to revisit their financial plan or potential investment strategy. To bold and underline one point there, Aaron, in 2017, the state tax exemption was increased, significantly increased. So it was 5 million and it increased up to 11.18 million, correct, in 2018?
Well, yeah, now it's been increased to 12.9 million.
12.92.
Right.
And that's, again, is a large number, very large number, and that's for an individual. A household would be double, correct? So it's roughly 26 million currently for a household.
Correct. So what that means, Nicholas, is that a husband and wife can own up to $26 million of asset without having to worry about estate taxes, and so having to worry about doing any sophisticated planning or wealth transfer strategies. Correct.
But in that example, as Congress leading the reason to revisit your estate plan, they're large numbers, but that's anyone that was around 10 million was impacted. That then increased to over 26 million. So that really changed the dynamic of who needed that sophisticated planning, for example.
Correct. And it's going to go down to approximately $6 million per person, or 12 million for a husband and wife, starting January 1st, 2026. So, again, a fairly high exemption amount, for many people, it may not implicate estate tax planning, wealth transfer strategies. But I will say, it wasn't too long ago, Nicholas, where that exemption was only $600,000, right?
Yep.
And particularly with, Democrats, they see, the estate tax and gift tax as a real target for, legislation. And so I wouldn't be surprised if the, Democrats took control of Congress and stayed in control of the White House, that there would be some real push to reduce that exemption amount, even if it's 6 million at the time, to something very low, and increase the estate tax rate, which is currently 40%, to maybe back to 55%, when,
Wow.
back then when it was a 600,000 exemption, it had a 55% estate tax. So you never know. I mean,
That's why this planning is so important. Good
that's
point.
yeah, that's why planning is so important. Absolutely.
That takes us to myth 8. An attorney, in fact, under a general durable power of attorney, can wrap up my affairs after death, being closing the bank accounts, obtaining information about life insurance, obtaining information about retirement accounts, or other information about digital assets.
Yes. So, important thing to understand here. An attorney, in fact, under a general durable power of attorney, again, so we're talking about someone given the power to handle your financial affairs when you're incapacitated. You're deemed to be unable to handle your own affairs and make decisions for yourself. It's a very useful, helpful tool, and one that's an absolute must in an estate plan. But it's only effective while you're alive. Once you pass away, the attorney, in fact, is rendered unenforceable. It's null and void. And now you're moving over to your will and revocable trust, and the people you've designated there as your trustee to take over. And sometimes the person who's been designated as the trustee is not always the person who's been named as the general durable power of attorney. So, the attorney, in fact, is only valid and in force while you're alive, although you're incapacitated.
Great information. Thank you. In myth 9, once I have my trust, my estate plan is complete.
Well, again, I don't want to sound repetitive here, but, it's important to hammer home the point that we've got at least 5 goals and objectives we're trying to accomplish. And only some of them are accomplished through the trust. We don't have guardians and conservators for minor children in a trust. We're not necessarily minimizing or avoiding estate tax with a trust, and we're certainly not addressing the situation where we're incapacitated when we have a trust. So that's number one. Number two, again, we talked about the 3 ways that you can pass assets, one of which is joint ownership. The other is by naming a beneficiary. I didn't talk about a trust there. That's the 3rd way. So a trust may be good for some of your assets, but joint ownership and a beneficiary designation may be the more appropriate way to do so as part of your estate plan than the trust. So you just can't rely on a trust. It's got to be a comprehensive, global plan.
And what does that look like for you, Aaron, and Taft Law, assessing that for a client situation, taking inventory to determine what the best route is or the best structure?
So for me, it's so crucial, it's so important to understand the client's balance sheet, their financial statement. And I really can't do that without you, right? you're the front line. You are the planner. You're dealing with the client on a regular basis, certainly in front of them, talking to them more often than me. The only way that I can really do my job is working in tandem with you, RWS, with the understanding of the total estate, the asset picture. What are the bank accounts, investment accounts, life insurance, retirement accounts, real estate. And once I have a complete picture of the assets, then I'm really in a position to do some appropriate estate planning.
Oh, thank you. So I have myth 10, I can do my own estate plan on the internet. There's LegalZoom out there. There's artificial intelligence getting more intelligent, it seems like, improving day by day, week by week. Fun story, I know of an individual that used ChatGPT, linked their TripAdvisor account, their credit card, and it booked the whole entire trip for them. So is ChatGPT the future of estate planning, Aaron, or is it tap law?
Yeah, look, estate planning is planning, right? Estate planning. Planning doesn't occur unless there's dialogue between people. And look, what you and I provide as a service, advice, we're advisors. And you don't get that when you go to the internet and you're working off of a form. You don't know what you don't know, right?
Yep.
And so you and I, accountants, we help the client understand what they don't know and address what they don't know. And it's a relationship. I mean, we're not just drafting documents. We're creating a relationship that lasts beyond the creation of the documents. And also making sure we're addressing alternate scenarios, certain, differences in, what could happen. And so, you really can't, the internet's can't do that for you. I mean, it's got to be a dialogue between the client and us.
The internet does not understand emotions or goals as well, too, if you can't define or articulate those goals yourself as a client.
Yeah, good point. That's absolutely right.
So with that, those are the 10 myths. We now lead to some common challenging estate planning scenarios, which would include blended families, succession planning of businesses, and multiple assets that pass differently. Let's start at the top.
Okay. So, Nicholas, how much time do we have? I just want to be, mindful of that and address these in the best way possible. So give me sort of an idea of how much.
You allocate how you want, but I say around 3 to 5 minutes, 2 to 3 minutes each,
Right.
We have some time.
Yeah, that's helpful. Okay. So we've been talking about the basics of estate planning, and hopefully, it's become clear what the goals and objectives are, and through the discussion of the common myths, you're starting to see a better picture of the estate planning process. So these are typical scenarios that I see that present challenges for Nicholas and I in developing an estate plan. And when I talk about blended families, there I'm talking about second marriages and children from a first marriage, and balancing what the clients want to do as far as leaving assets to their current spouse, as weighed against what they want to leave to children. Taking care of the spouse, but also making sure that the children are taken care of. And in the course of doing that planning, we have to be conscious of the estate tax, because it's real simple. If you leave everything to the spouse, we can guarantee that there'll be no estate tax if you do so, but that may not fit with the client's desire to want to make sure that their children from the first marriage are taken care of and aren't waiting until after the spouse dies before those children see any of the assets. And that could depend on what the estate taxes. Sometimes we handle it with very careful and managed drafting. Sometimes we handle it with specialized trust, or even sometimes with life insurance. We may, Nicholas may provide a life insurance policy for the client that would name the children as a beneficiary, for instance, so that the client knows that the children will receive something on their death, while leaving the other assets, like retirement assets and the home, to the spouse. So that's one very common scenario. And I will say also that what becomes interesting in that type of scenario is understanding who my confidences lie with. Who's my client? Am I working with both the husband and the wife? If so, then we have a joint representation, and I don't have confidences with one of those individuals against the other. Anything that's disclosed by one has to be disclosed to the other. So it's important right out of the box, understanding who the client is and who my confidences and attorney-client privilege will be with. The second common scenario is succession planning of a business.
Mhm.
And that's, what are we doing with the business? Do we have some of the children working in the business while some aren't? How are we going to treat the ones that are working in the business versus the one that aren't in the business? Do we treat them equally and leave the business to all of the children? And how does that work? What sort of dynamic does that create with some non-working family members owning an interest and having a say at the table, the board of director table, with those that are active in the business? Does that create tension, animosity? If we're going to leave the business only to the ones active, how do we do that in the most tax efficient manner? And if we're doing that, how do we treat equally the other children who aren't active in the business? Are there key employees who have an expectancy to become owners of the business? How do we bring them in, and how do they work with family members? Do we have owners of the business, partners who aren't family members? Should we have a buy-sell agreement between those owners, so that if one of the owners dies, the surviving owner doesn't have to deal with the spouse as an owner sitting at the table as a decision maker? Very complex, sophisticated issues that aren't always driven by tax issues. They're driven oftentimes by emotional issues. So, those are interesting challenges that create, some issues that, if not addressed properly, can really cause some problems with family and key employees on a death and even a disability.
Another point there, Aaron, just to add on that, is disability. Whether it's permanent, if it's permanent disability from cognitive or physical, that can also provide a lot of strain there on the partnership and the succession planning nature of the business.
Yeah, absolutely. And you know what? Another scenario is a divorce, right?
Yep, exactly.
You have a active child who's in the business, who's got some ownership, and now is getting divorced, and the ex-spouse is claiming that they're entitled to half of the ownership in the property. That can cause some real problems for the ongoing business operations. Now that ex-spouse is asking for financial information, for appraisals of the business. You can probably avoid some of that maybe with a prenuptial agreement or a buy-sell agreement. But the point I got to drive home is you got to have a plan. And oftentimes, family don't have a plan because they're paralyzed by analysis. We say paralysis by analysis, right?
Yeah.
And by being faced with the challenge of making some really hard, tough decisions. Hopefully you've got good advisors like you and me who raise the issues, who help guide them, make the process, easy, not easy, but manageable. But you can't bury your head in the sand. You got to address them head on, and you got to have a plan. Without it, things can be disastrous.
We've both seen that side of it, so agreed.
Far too often,
Yep.
too often. Absolutely. And then the last issue is, you've got a family, and maybe a blended family, for instance, where the client says, I want to leave a certain amount of my assets to my spouse, and then the other amount of assets to my children. And they simply say, I'm just going to put in my document, my trust, I want 50% to go to my spouse and 50% to go to my kids. Well, but what if the house is owned jointly with the spouse? That's automatically going to go to the spouse, irrespective of the 50-50 split. What if the spouse is named as the beneficiary of a very large IRA, account? That's going to go to the spouse, irrespective of the 50-50 split. So now all of a sudden, the spouse is getting the house and the retirement assets and getting 50% of everything else, where, the client really intended for the house and the retirement asset to be part of the 50%, right? So again, if we're doing our job correctly, we're looking holistically at all the assets, understanding how they pass, and actually probably putting together a flow chart that says, okay, we've got different buckets. We've got the retirement asset bucket, we've got life insurance bucket, we've got real estate, and we got everything else. And if you look through those buckets, how are each of those passing? And at the end of the day, are they passing in a proportion, in an amount that we want to go to either certain children and or, the spouse?
And whether it's a business going to their 3 children, or if it's a mom and dad passing that cottage up north to their children, they may have preferences of what they desire or not from an estate planning standpoint. So that's part of that emotion and that planning part of it, correct?
Correct. You raised another common scenario. I'm sorry I didn't put it here, but that's the second home, the cottage up north, right? And you leave it to, let's say, both husband and wife pass away, and now they've left it to their 4 children.
Mm-hmm.
And without any sort of guidance, who gets to stay in the house and use it when? And what if some are financially capable of handling the property taxes and the maintenance and the upkeep, and some aren't? What do you do when, certain children are footing the bill to maintain that cottage and others aren't? What if they can't agree on who's going to stay there, during 4th of July weekend? It's really important sometimes to have what we call a cottage trust or a cottage LLC in place to lay out and provide guidance, governance, management of the cottage.
Absolutely. It comes into the financial planning more times than not. Here lately, well, I want to VRBO it and my siblings do not. So
yeah.
Well, thanks for that. And everyone here, again, the phone number, if you do have any questions, please text us now. We're gonna next slide touch on a few of the questions I believe came in. 833-797-4636. So with that, let me go back, apologize. One was, what is the process? So walk us through if it's a 5-year-old, a 10-year-old, or 20-year-old estate plan. Is it a free consultation or review of their documents to see if things have changed or there's opportunities or different ways to structure? What's the process with TAF?
So if I'm presented with an opportunity to meet with a couple that has an existing estate plan, whether it's 5, 10, 15 years old, and they're looking for consultation, what I recommend is sending me the documents for review and I have a questionnaire, but Nicholas, sometimes I rely on you to provide me with the financial statement for the couple, taking a look at the documents in the financial statement, and then meeting with the couple Usually takes about an hour and a half to go through where I see some problems, some concerns, make some recommendations. Uh, and then quote a fee. Here's what I think it's going to cost to do what I'm recommending. And if the client isn't interested in moving forward because they think it's too expensive, or they don't think it's a good personality fit, or we determine that there's really not much to do, everything's in good order, good shape, no charge for that consultation. Happy to do it as a courtesy to you and your clients. The other thing is, by providing a quote and them agreeing to move forward, we're all on the same page. There's no sticker shock. We go into the project, the relationship, eyes wide open. And that's really how I try to do things, even after we do the initial estate plan. If there's things that come up in the future, amendments or changes, we'll try to provide a quote of what we think it's going to cost so that there's no surprises.
Thanks, Aaron. It looks like we were very thorough and addressed a lot of questions throughout. That's about it. So I'll end with this slide. Monthly, the last Thursday of every month, 7 p.m. Eastern, our webinars with RWS. July, we have Medicare Basics. In August is optimizing your Social Security benefits. And in September, we have a strong keynote speaker frequently seen on CNBC and Bloomberg Weekly, provide a market and economic update. So rwsgroup.org/events, please register. The recording will be on YouTube probably in a few days here of today's presentation. We'll end with a fun question for you, Aaron. Last weekend was the official first weekend of summer. We have a lot of summer ahead of us. Any fun, noteworthy weekend plans or summer plans or 4th of July?
Yes, so I have a place, a cottage up north in Charlevoix, and so we're going to head up there and spend some time with the family.
Very good. Well,
Yeah.
enjoy, and thank you, Aaron and Taft Law. We appreciate your time, your knowledge, and thankful for our strong partnership.
Yeah, thank you, Nicholas. I really appreciate the opportunity to be able to speak and provide some guidance on estate planning. Thank you.
You're welcome. Estate plan, tax plan, investment plan, and ultimately your financial plan, they're all integrated. They're all incredibly important. Thank you for attending. We appreciate it. It means so much for your attendance, and we'll see you on a future one. Take care.
Thank you. Take care, everyone.